let us discuss voluntary easements. But before that, let us define what an easement is under the Philippines property law. So, what is an easement? An easement is a real right on another's property, corporeal and immovable, whereby the owner of the latter must refrain from doing or allowing somebody else to do or something to be done on his property for the benefit of another person or tenement. Examples of easements are easement of right of way, easement of drainage of buildings, easement of light and view. So easements are like burden over onto another's property or to the servient estate in favor of the dominant estate, like sa easement of right of way. So easement is a real right requiring the owner of a real property or the servient estate to refrain from doing or allowing something to be done or somebody else to do something on his property for the benefit of another person or tenement or to the dominant estate. Easements are established either by law or by the will of the owner or through agreement of the parties. Easements of the former category are called legal easements, while under the latter are called voluntary easements, which is our topic for today. Voluntary easements under Article 688 of the Civil Code provides that every owner of a tenement or a piece of land may establish thereon the easements which he may deem suitable and in the manner and form which he may deem best, provided he does not contravene any laws, public order, or public policy. So let's have an example. In the case of Tres versus Araneta, whereby the property owner of the subdivision property asserted that the restrictions on her title created a restriction or a limitation daw for the building of factories and that it was invalid or illegal kasi it curtailed his right of ownership. Sabi ng Supreme Court, no. He has the right to the property kasi siya yung owner, provided that he does not contravene any laws, public order, or public policy. Kasi nga, sabi ni Article 888, every owner of a tenement or a piece of land may establish thereon the easements which he may deem suitable, and in the manner and form which he may deem best, provided he does not contravene any laws, public order, or public policy. Next article, the owner of a tenement or a piece of land, the usufruct of which belongs to another, may impose thereon, without the consent of the usufructuary, any servitudes which will not injure the right of the usufruct. So what is a usufruct, by the way? So a usufruct, it is a right given to a person to enjoy the use of the property, provided that he will maintain or preserve the form and substance of the property. So kumbaga, he is given the right over the property temporarily. So yun. So example, this property is owned by A, the best friend of B. So this house is subject to usufruct. So si A, being the owner, can impose any servitude, like for example easement of right of way dito sa property kasi siya yung owner. So even without the consent of the usufructuary or consent of B, he can impose any servitude provided na it will not prejudice the right of the usufruct. So yon, a usufruct gives a right to enjoy the property of another with the obligation of preserving its form and substance. The only condition is that the servitude will not injure the right of the usufruct. Kasi binigay mo sa kanya tapos hindi pala siya makaka-benefit, so it will defeat the purpose of the usufruct. So next article naman has something to do with beneficial owners. So let us read Article 690. Whenever the naked ownership of a tenement or a piece of land belongs to one person and the beneficial ownership to another, no perpetual voluntary easement may be established thereon without the consent of both owners. So, ano yung beneficial owner? So, for example, this house is owned by A, B's father. So, B has an inchoate right over the property kasi anak siya ni A, di ba? So, a beneficial owner daw is a person who enjoys the benefits of ownership though the property's title is in another name. So, nakapangalan pa kay A sa kanyang father. Article 690 talks about perpetual voluntary easement. Lifetime easement na siya. So, dapat may consent si B. Kasi siya yung beneficial owner. Yun yung sabi ni Article 690. No perpetual voluntary easement may be established thereon without the consent of both owners. Also, there are rules when there is a usufruct. First, the beneficial owner may by himself create a temporary easement compatible with the extent of his beneficial dominion kung hindi siya perpetual easement. So, pwede siya. Temporary easement lang. Second, if the easement is perpetual, as a case in point, both the naked and beneficial owners must have consent. Thank you.